today to talk about workers' compensation legislation changes for the state of Ohio. My name is Rob Solt IV. I'm one of the associate attorneys here at Bugbee & Conkle, and I focus primarily on workers' compensation litigation and labor and employment law. Joining me is Professor Mark Barnes, who's one of the partners here, who, in addition to being a partner in litigation, he is actually teaching the future lawyers of the state of Ohio the proper litigation techniques at the University of Toledo College of Law. So, Mark, thank you for joining me, and hopefully we'll get you a little bit more information on what has been going on in the state of Ohio. So, obviously, 2020 has been a very uneventful year so far, with nothing much going on. But that being said, the legislature decided to make some fairly sweeping changes to workers' compensation law that will drastically affect how employers deal with claims, as well as how attorneys and how we'll defend claims as well. So first thing is the mechanism that was used to make these changes was House Bill 81, which was signed by the governor on June 16th of 2020. What that is important for is it basically makes an effective date for the litigation, or for the legislation of September 15th of 2020. Now, most bills, when they pass, the effective date is the effective date for all the different sections. House Bill 81, it's not. So we're going to go through specifically and what that September 15th, 2020 date, which provisions it affects. There are several different areas that we're going to cover in depth. The first one is going to be voluntary abandonment. Second one will be the changes to the VSSR, the settlement authority of state fund employers, and then the statute of limitations or the life of a claim as well. So we're going to start with voluntary abandonment. There's a couple other miscellaneous provisions that we also will be dealing with at the tail end of the presentation as well. All right. So voluntary abandonment. Mark, what exactly is voluntary abandonment, and why is that something that's important for employers?
Well, most employers that have been involved in workers' compensation for any length of time understand that when an employee leaves the workforce for reasons other than his work injury, that it may have a preclusive effect on the ability to receive certain forms of compensation. So that would be temporary total disability compensation and permanent total disability compensation primarily. The wage loss rule also has contained a provision that also requires that the wage loss be connected to the injury. It's a little bit less forceful provision in terms of what voluntary abandonment would mean. The courts really didn't define the effect that a voluntary abandonment would have in the wage loss context, but in terms of temporary total disability compensation and permanent total, the courts have given it some meat. And primarily, when you're talking about voluntary abandonment, you're talking about two concepts. You're talking about quits and you're talking about firings, both of which the Ohio Supreme Court has defined as voluntary abandonments because the employee has control over the separation from employment. And that applies also as I said, in the discharge context, because when an employee takes an action that he knows is going to result in his termination, he's taken control over the separation, and therefore the courts have construed that as a voluntary abandonment, just like a quit. The case law also applies to things like incarcerations and retirement as well, because those are situations in which the employee has left work for reasons that are within his or her control.
Okay. Now, House Bill 81 has actually made a couple different changes, primarily only to the temporary total disability portions of the application of voluntary abandonment and the permanent total disability portion. So under the temporary total disability, House Bill 81 effectively changes that if an employee is not working or has suffered a wage loss as a direct result of reasons unrelated to the allowed injury or the occupational disease, the employee is not eligible to receive that compensation. So, kind of the inverse of that, in order for an employee to receive temporary total disability, the claimant must be, first off, physically unable to work, or must suffer a wage loss as a direct result of an injury or an occupational disease. And this does prohibit a claimant from receiving such compensation when the claimant is not working or has suffered a wage loss as a direct result of reasons unrelated to the injury or occupational disease. In regards to the permanent total disability, previously in 5123.58, which was the statutory provision that dealt with PTD, there was the language voluntary abandonment did actually appear within that statute. So what the House Bill 81 does is it effectively completely eliminates that provision from the statute. However, for PTD, it does still specifically include that a person may not receive PTD if a person is unable to engage in a sustained remunerative employment for one or any combination of the following reasons. First, retirement is unrelated to the injury or the occupational disease. The person's impairments are not a result of an allowed injury or occupational disease. It's solely due to the person's age or aging, and the person is not engaged in educational or rehabilitative efforts to enhance the person's employment unless such efforts are determined to be in vain. So it does keep the provisions that previously did exist that limited the PTD. However, it just removes that language for voluntary abandonment. Now, the cases, there is a case that is actually mentioned by the legislature in their footnotes regarding the changes to voluntary abandonment, and that is Gross v. Industrial Commission. And Mark, how exactly, can you explain Gross and how the changes may or may not affect that case?
Sure. First, let us back up for a second, because what House Bill 81 essentially did as far as voluntary abandonment is concerned, essentially the General Assembly codified the Supreme Court's holding in a case called State ex rel. Klein, K-L-E-I-N. And in that case, the Ohio Supreme Court overturned some of its previous precedent that allowed for some exceptions under the voluntary abandonment rule. Okay, most of you know that in the discharge context, voluntary abandonment is governed by, or has been governed by, the Louisiana Pacific case. In terms of quits, for the most part, a quit generally has always had a preclusive effect on on temporary total and permanent total disability compensation. However, there were some cases that arose after 1990 and into the 2000s that started to confuse the whole issue of when a separation from employment would have a preclusive effect on the receipt of compensation. The primary case was Pretty Products, which a lot of people, including the Ohio Supreme Court, interpreted to mean that when somebody is currently disabled or disabled at the time of their separation, that TT will not be precluded because you cannot abandon a job from which you are already disabled. And so that concept kind of muddied the waters. A couple other Supreme Court cases followed that and made further exceptions when, for example, the termination occurred shortly after the injury or shortly before the injury. The idea being that when an employee is disabled at the time of the separation, that disability would trump the voluntary abandonment doctrine. This case, Klein, came out 2 years ago, and 2 years ago, basically Klein found that those older cases are no longer workable. So it was a big case in the sense that the Supreme Court reversed its previous case law. So there has been this confusion in this area caused primarily by the Ohio Supreme Court trying to carve out different exceptions, and finally it got to the point where it said enough is enough. We're not going to carve out any more exceptions. If the separation, or if the separation from work is unrelated to the injury, then that separation from work will preclude temporary total disability compensation and permanent total disability compensation. When the court made that decision, it left alone this Gross case. Most people know the Gross case because it involved an employee at Kentucky Fried Chicken who violated a work rule in the way that he was operating the fryer, and he sustained a pretty serious injury. And he was terminated for violation of the work rule, which also in part seemed to be connected to his work injury. Well, the Supreme Court found in Gross that when there is a very close nexus, temporal nexus between the injury and the violation of the work rule, or the basis for the separation from employment, then the separation from employment is causally connected to the injury. And if that's the case, then the employee remains entitled to temporary total disability compensation. House Bill 81, which follows very closely in its purpose what the Supreme Court attempted to do in the Klein case, is relatively silent as regards to its impact on Gross. Even though Gross might be in the footnotes to the bill analysis, it's unclear whether Gross remains good law, and my gut feeling is that it is still good law, because the Supreme Court held that when you do have this close nexus in time between the termination or the separation from employment and the injury, that invariably there is a causal connection. And because there's a causal connection between the separation from employment and the injury itself, that separation cannot be used to preclude temporary total or permanent total disability compensation. So notwithstanding what you have in the statute now, I believe that there's still an exception when you have injuries that are very close in time to the separation. The same would be true for a post-accident drug test, which results in a termination as well. Because but for the injury, the employer would not have conducted a drug test. And if the drug test comes back positive, it's, connected in some way to the fact that there was an injury. If that's used to terminate somebody, obviously, an employer can terminate for whatever reason they want to, but that termination is not going to preclude temporary total. When the Supreme Court decided Klein, it left alone Gross, and it also left alone a case called Cordell, which dealt with the post-accident drug test scenario. So I think those are two areas, at least, in which the new House bill is probably going to be ineffective.
Thanks. And speaking of effectiveness, the effective date of this portion of the House bill is going to be for claims that are on or pending or arising on the effective date of the bill, which again is September 15th of this year.
And I would just note that language pending on or arising after is significant. Most times when there are amendments to the workers' compensation statute, it applies only to claims on or after the effective date. This statute uses the word pending. So that means that a claim that has a date of injury of, pick a date, 1995, which remains active for whatever reason, especially in the self-insured context, that claim would be pending. And so, the change with regard to voluntary abandonment would apply to older claims as well as those that are newer claims under the statute.
And in keeping with consistency, House Bill 81 does use that pending or arising on the effective date in a couple other places within the bill itself that we'll touch on as well. So moving along to VSSRs, or violation of specific safety regulations. As many of you know, that these are a pretty big deal when it comes to the employment section, and defending them is something that is very important for all employers. Under the prior law, the time in which an injured worker had the ability to file a claim for a VSSR was 2 years from the date of injury, or 2 years from the occupational disease. Under House Bill 81, it significantly reduces that to 1 year for both the injury and the occupational disease. This is obviously it's a great step for employers, because as a litigator, one of the things that we look for the easiest way to defend a claim, and if a claim is filed out of time, that certainly provides a very strong argument to resolve the claim relatively quickly. The effective date of this portion of legislation, again, is for dates with the injury is on or after the effective date for the new law. So claims that happen on or after the September 15th date of 2020, those are the only ones that we're going to be concerned with the new regulations. The Employer Settlement Authority. House Bill 81 does provide a relatively small change in regards to the ability for a state fund employer to effectively object to or withdraw from a settlement agreement that's rendered in a court case for these types of claims. So what House Bill 81 does is it effectively changes so you cannot withdraw from the settlement during the 30 days between the execution and the effective date of the settlement when an employee is no longer employed by the employer, or the claim is no longer in the employer's experience period. The effective date of this portion is pending, again, that nebulous word pending, on or arising after the effective date of the bill, so September 15th, 2020.
And I'd note that for state fund employers that are on the line, that the reasoning, it appears, behind this amendment to the statute is to prevent employers who no longer have an interest in the claim, no longer have a financial stake in the claim, from preventing the Bureau from shutting them down. When you think about it, most people don't think too hard about it except for us lawyers, but the money in a state fund claim belongs to the Bureau. Whenever you settle a state fund claim, the Bureau is the one that pays the proceeds. The only reason the employer is involved is because any proceeds in settlement are considered claims costs, and therefore it can affect the employer's premiums. But when the claim is out of the employer's experience, the employer no longer has an economic interest. The employer could still have an interest if the employee is still on their payroll, because then you have the morale issues of settling with a current employee. The employer may want to interject in that settlement because it could send the wrong message to the workforce when somebody's currently working for the employer and receives a workers' compensation settlement. So the employer still has an interest. However, if the employee is no longer there and the claim is out of the employer's experience, the employer shouldn't really have a right to interject in that settlement and shut it down because it no longer has an interest whatsoever. And I think that's the whole reason behind that amendment, is to allow the Bureau to handle claims in the way it sees fit, and not to restrict them from a potentially spiteful employer who wants to stick its nose where it no longer belongs.
Thanks. Moving along for the statute of limitations, it's really more of the continuing jurisdiction of Industrial Commissioner 4123.52, and also we kind of refer to this as the life of the claim. So under the prior law, we were looking at one of the ways to cap that claim was 5 years from the date of last paid compensation. Okay, well that's great and all, but what exactly does that mean? And that includes that last paid compensation includes payment of medical payments, and so there's a big ambiguity. All right, so if someone undergoes a medical treatment and let's say that gets billed out, there could be a lag of several weeks to several months to even longer until when that compensation, when those medical payments are actually made. So House Bill 81 does make great strides in clarifying that, and effectively says now the date is 5 years from the rendering of service. So we're not dealing with how long it took for the medical payments to actually be made throughout the billing. And so what this does is, it, again, is similar to the VSSR changes. It significantly shortens the time limit for a claim to in this case, be alive. So again, when defending claims, we're always looking to see, is it filed timely? Is the claim still alive? And this will go a long way to help employers and shorten the length of many of these claims. The effective date of this provision is July 1st, 2020. So, of course, as I said, House Bill 81, they have different effective dates for almost all the different provisions. This is a very concrete date. So even though the effective date of this provision is earlier than the effective date of the bill, it still establishes a concrete date, and that's the date to keep in mind. House Bill 81 also includes several miscellaneous provisions that I'm going to just briefly go over. First off, they include a provision that the administrator or self-insured employer must pay for services used to determine whether detention facility employees sustained injury or occupational disease after exposure to another person's blood or bodily fluids. I can tell you as an aside, long before coming to Bugby and Conkle, I worked as a public defender and spent quite a bit of time in the Lucas County Jail, and I can tell you that spit does happen. So this is primarily, again, directed toward the detention facilities and those employees. Additionally, they included a provision within that section that the administrator or the self-insured employer is to pay for services used to determine whether or not specific safety officers, including, and this doesn't also include the detention facility employees, sustained injury or occupational disease after exposure or to any other chemical substance. My understanding of this is primarily with law enforcement officers and detention facility employees when conducting searches. Many times people will have prohibited substances such as either heroin or fentanyl or some other type of chemical that can adversely affect those that are conducting the searches. So this provision is pretty limited in scope, but effectively it's saying that if there's a potential for exposure in those limited circumstances, the administrator, the self-insured employer, does need to provide those services. This bill also increases the amount that the administrator is authorized to pay for a funeral expense from $5,500 to $7,500. Currently, that's set at it's a reasonable amount with the max at $5,500. So this does just increase that slightly. There is another portion, and I took the bullet point out just because it's kind of a very minor change. Is that in regards to when an industrial commission order gets appealed to the common police court, there is a method within the litigation that if there's a potential to settle the case before it goes to full-on litigation, one party can file a notice of intent to settle, and if the other party does not object to that, then the time in which to file a complaint in court is increased from 60 days to 150 days. That's been established law for 2 years. What House Bill 81 does do is it just includes the effective date as a concrete date, that being September 29th of 2017. The prior legislation that changed that law basically said from the effective date of this legislation, House Bill 81 just solidifies that, so there's no question.
Yeah, just to interject for a second, I don't know if, when we do these seminars and webinars, sometimes we speak quickly and sometimes we misspeak. So I just want to make sure that everybody's on the same page. The statute of limitations for the filing of a notice of appeal has been extended from 60 to 150 days. Rob said the complaint, and I know he knows it's the notice of appeal, but some people on the call may not know the difference. It's the notice of appeal that gives the common police court jurisdiction over the workers' comp appeal. After that notice of appeal is filed, then case proceeds like any other civil case, and under the statute, the claimant has 30 days to file a complaint. So just so that there's no confusion, what the statute did 3 years ago was it extended the time for filing the notice of appeal, whether it's the employer filing the notice of appeal or the claimant, from 60 to 150 days if this intent to settle is filed with the industrial commission and the opposite side does not object to it.
Yeah, thank you. I did misspeak. Sorry. Sometimes your mouth moves faster than your brain, unfortunately. So the last miscellaneous provision that is included in this provision is that it prohibits a private employer from furnishing services to a public employer under a contract governed by the Federal Service Contract Act from requiring an applicant to pay for medical examinations that they're required to as a condition of employment. So effectively, if an employer is under the Federal Services Contract Act, they can't require the employee to pay for the medical examination that they may require for that continued employment. So with that being said, there is, I see one question, and I'll last slide here. So the first question is regarding post-exposure testing. Does this only apply to safety officers? What about nurses or doctors? So the the Act defines a correction officer as a person employed by a detention facility as a correction officer. It does have a provision, though, that the following employees are also covered by the post-exposure testing requirement: a peace officer who has arrest powers, a paid volunteer firefighter of a lawfully constituted fire department, a paid or volunteered first responder, emergency medical technician basic, emergency medical technician intermediate, or emergency medical technician paramedic certified under the emergency medical services law. So to answer the question about nurses and doctors, it would appear that it would depend on how exactly. It's not a blanket for all physicians or all nurses, but it would depend if they fall within those specific categories that are enumerated by House Bill 81. All right. Does anyone other have any other chat questions? Oh, okay.
Somebody asks if, quote, pending on, end quote, for self-insured employers means claims that are active. What about a claim that was inactive but not settled and then was reopened? I'll try to answer that as best I can. The statute, I don't think, defines what's meant by pending. I think Rob, in one of the slides, mentioned that pending is not statutorily defined. But whether a claim is active or inactive, whether it's open or closed on a self-insured employer's books, is really the self-insured employer's business. I think what the legislature is getting at, though, is that if that claim has not been settled, okay, it remains pending. It's still an open claim, because unless that claim has been terminated by 4123.52, which Rob also spoke about. So that's the provision of the statute that gives the Industrial Commission continuing jurisdiction. Unless that claim is statutorily dead under .52, whether the employer categorizes that claim as inactive, I don't think would preclude the effect of the statute on that particular claim. I think it still remains pending unless it is closed by settlement or whether it has terminated under 4123.52 under that statute of limitations. Looks like there's another question regarding settlement authority. I've had several OOE settlements rejected by the BWC due to the lack of signature on the part of the employer. With House Bill 81, if a claim is OOE and the employer of record does not respond to the BWC's request for agreement to the settlement, will the BWC begin automatically settling those claims? And I'm assuming OOE means out of the employer's experience. Okay, thank you, attendee number 29. I think before House Bill 81, I think this is what House Bill 81 was designed to do, is to eliminate these situations where, because the Bureau always gets the signature of the employer, although as a practical matter, the Bureau can always settle over an employer's objections because they control the purse strings. That's always been the case. But I think as a practical matter, and the way the Bureau likes to do business, they want to get the employer's signature on the settlements, and it's probably a matter of policy with the Bureau more so than anything else that they're going to require that signature before they actually go ahead and validate that settlement. So I think that's what House Bill 81 is designed to do, is to avoid this situation in which an employer, either through its ambivalence or through intention, tries to, create an issue for the Bureau when they're trying to settle a claim. Any other questions? Going once, twice, 3 times.
So,
all right. Sold. If anyone has any other questions, feel free to email Rob or me, and we'll try to answer them.
All right. Thank you, everyone, very much for attending, and stay tuned. I'm sure there will be some future webinars coming out of our office, so we're always trying to keep up to date on the latest changes in workers' compensation law. So thank you very much.
Thank you.